So, but we have no objection.
Thank you.
That's mathematics.
Thank you.
Yes, sir.
So, 1 minute here.
Yes, 1 minute. I wish to address you on an issue that has not been addressed by my colleagues at senior, as to what should happen in the intervening period when you retire to render a decision on the validity of the charge before you. You honor the charge as rightly put is one under section 94.1, a misdemeanor. And in light of the provisions of article number 49.2, a violation is ensuing at the moment in that our client is in custody. Article 49.2, the rights of an arrested person, provide that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only or by imprisonment for not more than 6 months. The one before court is one that qualifies under 49.2. As such, in the intervening period, it will ask for release of the arrested honorable man on her personal cognizance.
Your Honor, Honorable Jayne was apprehended in Naivasha in her constituency and was escorted by a convoy of 30 officers, approximately, because she agreed us. Two Land Cruisers, Your Honor, and the famous Subarus. Only to be presented before you this morning, the charge is a misdemeanor. I believe it's on Saturday? Yesterday, Your Honor, lunch hour. When I spoke to her, she was at DCI headquarters last night. As senior counsel, I thought, from what she told me, we did not have to use public resources to come in this morning for a misdemeanor. So I tried to talk to the deputy DCI, who told me I was going to look into that matter. And if they had properly applied their minds, she should not be before you, Your Honor. That's our submission. Finally, Your Honor, I want to refer you to the provisions of Article 2 of our Constitution, which of course declares that this Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. Sub-Article 4, Your Honor, of section of Article 2, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or mission in contravention of this Constitution is invalid. Your Honor, my submission is that alleged breach of Article Section 94.1 of the Penal Code is unconstitutional. Because in violation of the very Constitution itself. And Your Honor, as Kenyans, we should be very proud that we imported the Article 20, 19 and 20 of the Constitution, the Bill of Rights. Therefore, it behooves all of us, Your Honor, our courts of justice taking leadership to ensure strict adherence with Constitution 2010 and its valuable provisions, which actually is a constitution that gives freedom of expression. We've been addressed on that. Therefore, our plea, in conclusion, Your Honor, is that this harassment through you should stop. I found you recently, I did not know whether it was before you, when we had the privilege to appear together with Chief Justice Emeritus in the case of Jayne.
No, it was a different one.
You look like...
He's not my brother.
Yeah, you look like... Your Honor, Jayne is a very good case to be found at this time. When the magistrate, your brother magistrate, simply let her off. When he retired to consider submission, Jayne is a free citizen. She did not have to plead to a ridiculous charge. We ask Your Honor that Honorable Jayne Kihara, whom I know as a mother and a senior leader, she had serving her third term in Parliament, should not be before you for a misdemeanor. So we urge that when you retire to consider application, that you let her off. In any event, you had the maximum sentence for such an offense, a fine of 5,000 shillings. A real misdemeanor. So we urge that you order immediate release of Honorable Jayne Kihara, and we ask our colleagues in the political space to just adhere to the Constitution. That's all we are saying. I thank you all.
All right, thank you, sir. That's all.
Thank you, Your Honor, once again. Must be afternoon already. Good afternoon.
Good afternoon.
Your Honor, we oppose the application for deferment and or rejection of these charges. And Your Honor, while we respect our colleagues on the other side, and we must commend them for a very good arguments today, especially my learned colleague, Mr. Njero, who I think must have preempted my arguments under Section 8. We've done this within several years. I could see what he was doing. But Your Honor, I understand the application for rejection and or deferment of these charges to be founded either on Section 89, 4 or 5 by Mr. Ndegwa, or Section 134 by Mr. Your name is difficult. Ruto. 89, 4 or 5, I think we could easily drop 89, 4, which deals with the drafting of charge. But 89, 5 about rejection of charges, or 134 as to, the propriety and contents of a charge sheet. And I thank Mr. Watuta for bringing 134 up, because Learned Senior Counsel has referred to a case before your brother, in which a charge was rejected on the basis of Section 89.5 on the same arguments, but which case from the onset we could say you're not bound by because it's a court of concurrent jurisdiction, so it's a superior court decision, and two, a decision which may have been issued in error, and I will tell the court why. The arguments, other than being based on Sections 89 and Section 134 of the Criminal Procedure Code, also is founded on a conflation of the criminal law vis-a-vis constitutional law of Kenya, and which needs some unpacking, a little bit of unpacking. And I'll say again that Mr. Ndegwa has done so well in his arguments on the constitutional perspective, which then is but for all of us, any court can only do as much as they are provided to do in terms of jurisdiction. Without jurisdiction, a court downs its tools, in which case you will down your blue pen if you are asked to do something outside your jurisdiction. As correctly noted by Mr. Legwa, the jurisdiction of the Magistrates Court to hear and determine criminal cases is provided for under Section 8, the jurisdiction of this court to hear and determine questions of alleged violation of the Constitution or of Bill of Rights is provided for under Section 8. Interestingly, I was listening so keenly, my learned colleague goes to Section 3, Section 4, then he gets to 8 and tells you Section 8.1. I want to read 8.1, which he referred to, if you permit me. I can go to that as they look for it for me because it seems it's not in my bundle. My colleague is assisting me with it. But in a sense, what it says from the reading as we wait for the actual text is that the magistracy have the power to interpret and apply the Constitution. Yes, correct. Thank you, sir. 8.1 claims relating to violation of human rights. That subject to Article 165(3)(b), which I'll come to shortly, of the Constitution, and pecuniary limitations set out in Section 7.1, a magistrate's court shall have jurisdiction to hear and determine applications. Hear and determine applications for redress of a denial, violation, or infringement of, or threat to right or fundamental freedom in the Bill of Rights. It does excellently well by bringing that out. But it leaves 8.2. Let's go to 8.2. The applications contemplated in subsection 1 shall only relate